You're sacked, you're dismissed. These are things that we have probably all heard from time to time, whether they've been said to us or we've heard them said to others, or we've been the ones saying them. But what do they actually mean legally? You're sacked doesn't actually have any legal meaning at all. And what it usually means is that somebody's having some kind of heated discussion where termination of employment is probably on the cards. In terms of the effective termination date though, you're sacked doesn't really mean anything and doesn't crystallise a termination date. You're dismissed, that may mean slightly more. It doesn't actually have a legal definition, but it does mean that employment is ending. Again, the date of the effective termination is still not known because just simply telling someone you're dismissed doesn't clarify whether there is any notice or any payment in lieu of notice. It may be that you've had to say to somebody before that it's time to part ways, but what does this really mean in the employment context? It's probably an indication that the relationship between the employer and the employee isn't working out. It's often or usually said before a formal discussion about when the effective termination date is, but simply saying to somebody it's time to part ways indicates that a further discussion needs to be had. If as an employer you have to say to somebody, we're terminating your employment summarily, what does that mean? Well, it means that you are terminating employment with immediate effect. It's essentially exactly the same as saying to somebody, your employment is terminated with immediate effect. What that means is that employment then terminates on that exact day that that is said. There is no notice period. Summary dismissal usually means that the employee has committed some act of gross misconduct or a fundamental breach of contract, which means the employer is entitled to terminate the employment without notice. If you are looking to summarily dismiss an employee, you do just need to be careful of how that notice needs to be served in accordance with any notice provisions in the employment contract. If you tell an employee that their employment is being terminated and they are being put on garden leave, what does this mean the effective date of termination is? If we take an example of an employee who has 3 months' notice and they are told at the beginning of January that they are being dismissed and put on garden leave, it means that their notice period will then run till the end of March. For the duration of that 3-month period, the employee will be on garden leave, which generally means that they are not required to come into the office, but are to be available should they be needed by the employer. It means that the effective date of termination will be the end of that 3-month period, which in the example I gave would be the end of March. During that 3-month period, the employer to an extent exerts control over the employee. The employee is not required to come to work for the employer, but is prohibited from seeking alternative employment. It means that the employer can try to protect any of the trade secrets or confidential information or key client relationships that that employee may have had and try to cement those between the employer and the third-party supplier, for example, so that when the effective date of termination takes effect, the employer has more control over those relationships. As an employer, you may wish to terminate the employment of an employee, but not have them work any form of notice. In this situation, provided that the employer has a contractual right under the contract, it may be possible to make a payment in lieu of notice. What this means is that provided the employer complies with the notice provisions under the contract, notice can be served on day 1 and the effective date of termination of employment can be day 1, and then the employer makes the employee a payment in lieu of notice.